I just want to welcome you all again. You're very welcome to today's Trinity Roundtable on the amendments to the Health Research Regulations. My name is Professor Mary McCarn. I'm Professor of Ageing and Intellectual Disability at Trinity College and Director of the Trinity Centre for Ageing and Intellectual Disability, which is the School of Nursing and Midwifery. And I was previously Dean of the Faculty of Health Sciences at Trinity. So this is, you can imagine, a very relevant and an important topic. And as many of you will be aware, the Minister for Health introduced amendments to the 2018 Health Research Regulations in January of this year. And these regulations provide clarification on the issues like retrospective chart reviews and deferred consent. And here at Trinity College, we very much pride ourselves on maintaining the highest ethical and legal standards in the planning and implementation of health research. And we're delighted to welcome a number of speakers today to provide us with their perspective on the amendments and what they mean for health research. So I really do want to welcome a great panel of people that we have joining us. David Murphy is the Assistant Commissioner with responsibility for the supervision and freedom of information in the Data Protection Commission. And David joined the Commission in 2016, and he has been doing stellar work around providing best practice guidance and advice to organisations across the public and private sector on compliance with data protection legislative frameworks. And he's also a member of the European Data Protection Board. So we're very much looking forward to hearing what David is going to advise us later on. Peter Lennon, I particularly want to welcome Peter. He works in the R&D and Health Analytics Division in the Department of Health, where he has responsibility for the health research regulations. And David has written a number of books on data protection and articles, and lectured indeed in many areas on health service management. Particularly want to welcome our own, I should say, Professor Louise Gallagher. Louise is Chair of Child and Adolescent Psychiatry here at Trinity College and Consultant Child and Adolescent Psychiatry at the HSE and Tala University Hospital. She's also a leader in the field of autism research in Ireland. She has a very critical role, I suppose, at the university level, and particularly within the Faculty of Health Sciences, where she is Director of Research at the School of Medicine and has been doing stellar work in the promotion of the awareness and education around our obligations in adhering to the regulations. So thank you, Louise, for all your ongoing work in this area. And also joining us on the panel today is Emily Verker, is the Programme Manager and Secretariat to the Health Research Consent Declaration Committee. And since the Secretariat's establishment in early 2019, she oversees the operations of the Secretariat, which includes advising on the consent declaration process and supporting the business of the HRCDC, enabling it to deliver its mandate under the Health Research Regulation. And to many of us, indeed, we at Trinity particularly, we all know Emily because she previously worked here in the field of technology transfer. And I particularly want to thank Emily for her ongoing, we are constantly in contact with the research that we are involved in, involving people with intellectual disability. And indeed, many of the discussions that we're going to have today is so pertinent to the work that we are doing. So thank you, Emily. I also want to welcome Evelyn Fox. Evelyn is Trinity's Deputy Data Protection Officer, and Evelyn has responsibility for advising researchers on compliance with data protection law. And many of you indeed will have had worked very closely with Evelyn. And again, I want to thank Evelyn for her stellar work in supporting researchers across the university, both on numerous queries, DPIAs, consent declarations, etc. So thank you so much, Evelyn, and lovely to have your insights today. And just before I begin, I would also like to remind you all that we will have a masterclass at this time next week, just exploring the issue of consent in relation to the health research regulations, which will be chaired by Evelyn Fox. So thank you, Evelyn, for doing that. And we're going to put a link into the chat box if you also want to register for this. This session is being recorded. I'm going to encourage people to submit questions if they have them to the Q&A section. I'm not going to deal with questions until the very end, where we'll have a panel discussion, to discuss the questions. We have had a number of questions already submitted. We will endeavour to get to as many questions as possible, but if we don't get to the questions, we will create a document which we will circulate to attendees after the event, where we will try to provide some answers to your queries. So without any further ado, I'm going to invite now David Murphy to present to us on putting the health research regulations in the wider data protection context. Welcome. Thank you, David.
Thanks very much, Mary. Good afternoon, everyone. I'm delighted to be here with you on behalf of the DPC, and thanks to TCD for putting this, I think, very important event together to develop the conversation around the health research regulations in light of the amendments. So as Mary said, what I'd like to do, briefly, in the 20 minutes that I'm going to speak to you, is to really put the health research regulations into the wider data protection context and where they fit in the data protection legislative frameworks and in terms of organizational responsibility. And then I think this will tie in quite well with what Peter is going to address in terms of a sort of a deeper dive into the regulations themselves and what the amendments bring. The first thing I would like to point out, when we're talking about data protection, I think it's often important to bring it back to basics and remember that what we are talking about is the protection of fundamental rights. And these are fundamental rights that are granted under the Charter of Fundamental Rights of the European Union, under Article 8, which specifically addresses the protection of personal data. And Article 8 provides, firstly, that everyone has the right to the protection of personal data concerning him or her. It provides that such data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. And it specifies that everyone has the right of access to data which has been collected concerning him or her and the right to have it rectified. So I think it's really of fundamental importance when we think about data protection in any context, not just in health research, to just bear this in mind, that what we are talking about is the application of, and the respect of fundamental rights granted to under the Charter to citizens and to people living within the European Union. And then, of course, Article 8.3 provides that compliance with these rules shall be subject to control by an independent authority, which in Ireland is the Data Protection Commission, formerly the Office of the Data Protection Commissioner, but re-established by the Data Protection Act 2018 with responsibility to monitor the upholding and enforcement of these fundamental rights in Ireland. When we talk about data protection law, we are of course not simply talking about GDPR. There's a framework of legislation that underpins the work that we do. And I think is really worth bearing in mind that when you're working in the area of data protection and trying to apply it, you're not simply looking at one little piece. It's not just about the health research regulations, it's about seeing where they sit in the wider context. So the Lisbon Treaty of 2009 brought the Charter of Fundamental Rights, to which I've just referred, into legal effect across the European Union. And then coming from discussions that commenced really in 2012, the General Data Protection Regulation came into effect in 2018, putting into legal effect across the European Union principles of data protection as outlined in the Charter. It's worth noting, of course, that in addition to the Data Protection Regulation, Directive EU 2016/680 applies the same principles in the context of law enforcement. And both the regulation and the directive are given specific iteration in Irish law under the Data Protection Act 2018. But that's not where it ends. When we talk about data protection law, we also have to bear in mind the European Community's Electronic Communications Networks and Services, Privacy and Electronic Communications Regulations 2011, which are commonly known as e-privacy regulations. And these apply to electronic communications such as email, SMS contacts, and so forth. And if you are conducting a study, if you're enrolling people using email addresses, other forms of contact, it's worth bearing in mind that you do have obligations under e-privacy regulations, specifically when it comes to unsolicited communications or anything that could be considered direct marketing. So you really need to bear in mind that there may be other matters, other applicable frameworks than the health research regulations, which of course were made under the Data Protection Act of 2018 under section 36(2), and I'll speak a little bit more to that in a moment. We don't have, as I say, a huge amount of time to do sort of a deep dive into data protection and how it works, but what I'd like to just focus on for a moment is the concept of the controller and processor. The obligations with regard to the rights of the individual to the protection of their personal data fall upon what are termed data controllers in data protection law. A controller is defined as the natural or legal person, public authority, agency, or other body, which alone or jointly with others determines the purposes and means of the processing of personal data. So this obligation falls really at organizational level, and it's the organization that is seen to be in effective control of data. And control means that it's the organization, it's the body that determines the how and the why of the processing of data. So why we obtain data, why we collect it, and what we're going to do with it. The processor then is the natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. So in the relationship between the controller and processor, the controller remains at all times in control of the data, as in determining the purposes and the means of processing. And what they are doing is essentially delegating an activity, a processing operation to a third party, a data processor. And this must be done under the framework of a data processing agreement or a data processing contract, which is set out in Article 28 of the GDPR. Now, to go back to the definition of controller, you'll note that it says alone or jointly with others. So data protection law recognizes that multiple organizations may come together with a shared purpose and together determine and define the purposes for processing and the means for which they're processed. And we know that this can happen in the context of scientific research, of health research, where multiple parties are joined together and determining the purpose of a study, what data will be collected, how it will be processed, etc. What I want to stress here is that it's absolutely key that the correct application of these roles in terms of the end-to-end processing of data prior to the commencement of any project is clearly set out, and that everyone has a clear understanding at which point of the chain they may be a controller, they may be a processor, and it's important to bear in mind that the same organization may in fact operate in different roles at different points in the process. So and again, all of these matters are very heavily context driven and must be determined on a case-by-case basis in respect of a specific project. But I think what's important to remember is that you don't need to apply the same designation of controller, processor, or joint controller in a manner that encompasses an entire project. You need to be aware, when you look at each specific operation, each specific process in your project that involves the processing of personal data, what's going on and who wears which hat, so to speak, bearing in mind that the same organization may at a certain point be a controller. They may then process the same data or related data sets on behalf of another controller, and then they may entirely drop out of the project and have no specific engagement. In terms of joint control, there may be a situation where two organizations identify that they jointly determine the purposes and means of the processing of the personal data, or they may in fact be operating as entirely independent controllers for different aspects of a project or related research. And what they are doing is transferring and disclosing data to another controller to carry out their part. So what's really fundamental is before you start processing data, to understand what those roles are. And there's a lot of guidance. The DPC has guidance. The European Data Protection Board has also published guidance on understanding the meaning of controller and processor in context, which I don't really have time to go into this afternoon rather. I'd like to touch on what the responsibilities of the controller are. As I mentioned, in our field, in the data protection field, it's the responsibility of the controller to uphold and to to ensure that the rights of individuals are protected. And the GDPR sets out, in a number of places how that is expected to be done. A general obligation is provided under Article 24 of the GDPR that the controller must implement appropriate technical and organizational measures to ensure and to be able to demonstrate that processing is performed in accordance with this regulation. So that's really a twofold obligation. Measures must be put in place to ensure compliance in the first case, and then to be able to demonstrate compliance, which is the principle of accountability under GDPR. And that accountability really, in my mind, is twofold. You need to be able to demonstrate your compliance to the regulator, to the supervisory authority, which is the DPC in Ireland, but also to individuals. Individuals must be able to see that the organisations that they engage with are treating their data in a compliant manner. And that then touches on the principle of transparency, which is extremely important, that people are fully informed as to what's happening with personal data. Article 24(2) then goes on to state that within the scope and looking at what you're actually doing with data, you need to implement data protection policies as appropriate. And that's really on the basis of risk assessment. But I would suggest, best practice would suggest that certainly in the area of health research, an organizational data protection policy, setting out what people are expected to do, what their roles are, would be very, very, very appropriate at organizational level. And again, there's a lot of guidance on how to formulate an adequate data protection policy. Something I'd like to stress this afternoon is the Article 30 record of processing. This is something that I think is key really at organizational level. The record of processing is at an organizational level designed to reflect everything that an organization does in terms of the data that it holds and processes. And if an organization, for example, Trinity College, has research going on, research being conducted, its record of processing should reflect this. This doesn't mean that that the record needs to list or to itemize all the data being processed. It simply means that it needs to be reflected that the organization has oversight and understanding of what's going on in terms of the data that's coming in and going out and being processed in the organization. Article 35 sets out the requirement to conduct a data protection impact assessment on the basis of risk. And this will be, I hope at this stage, well understood by people in the research community. The requirement, and this is of course reflected in the health research regulations, the requirement to assess the impact of the processing of personal data. What I would say briefly on DPIAs, we see a lot of them in the DPC, and we are always open and happy to informally consult with people on their DPIAs and give any advice and guidance. As a general observation, what we find often lacking is a clear centering of the individual, of what we call the data subjects in terms of risk assessment. So we're not looking for organizational risk or risk to the project, and we're not asking for a justification of the value of the project. It's important that when conducting a DPIA, you focus on the individual, their rights and freedoms under the GDPR, and any risk arising from your processing and how to mitigate that risk. And then I've mentioned Article 28, data processing agreements must be in place where the controller is delegating any of those processing operations to a third party, to a processor, and that must be in place before commencing any data processing. So to return briefly to the health research regulations, of which Peter will speak in much more detail, just to set in context in data protection law how the regulations arise and where we in the DPC see them fitting. So they're not out there in isolation. They are not in some way, they're an independent rule book for health research. They're very, very much part of data protection law and sitting within the general obligations of the controller. Article 89 of the GDPR sets out the conditions for the conduct of, amongst other things, scientific research. It also refers to processing for statistical purposes and for historical research, etc. But we're concerned with scientific research. And it requires, and it sets out that specific safeguards and derogations relating to processing for scientific research purposes may be brought into effect in member state law. This is done in the Data Protection Act under Section 42, which provides that the processing for scientific research purposes must be done with specific suitable and specific safeguards to protect the rights and freedoms of individuals. And then when we move to Section 36, we understand that what those suitable and specific measures are to safeguard fundamental rights for processing. And under the section, the Minister has the right to make regulations specifying particular measures, which leads us to the health research regulations. So that's in context where the health research regulations sit, but they form, in our view, very much part of the general compliance obligations of an organisation under both the GDPR and the Act. And really what they do is they extend the specific safeguards that must be put in place to protect personal data for health research purposes. I'd like to briefly talk about data protection officers. I think there's probably a few data protection officers in attendance this afternoon, and you're very welcome. It's always great to meet with DPOs. They are our main form of contact on the ground, and we couldn't do our work without DPOs. I'd like to just speak a little bit about how we see the role of the DPO in the health research context. So the primary function of the data protection officer is to inform and advise the controller or the processor of their obligations in terms of data protection law. So they are, in many cases, it's a mandatory position. An organization may also, on a voluntary basis, put a DPO into position. But they have that, it's sort of a dual role of providing information, but also advising. They have a high level of independence and should have a high level of access to the organization at a high level to really be able to step in and stop something happening if they think it's not being done in an appropriate manner. But when we look at health research, they must be facilitated in providing advice where requested as regards the DPIA and monitoring its performance. They must be brought in and involved properly and in a timely manner in all matters relating to the protection of personal data. And by timely, I mean, I think what it's looking at there is that they're not brought in last minute and asked to sign a document before something goes live, the next morning. And as I mentioned, they are the point of contact for both ourselves as the supervisory authority, and they are the point of contact for individuals who wish to exercise their rights and to obtain information. And they can't fulfill those functions if they are not involved properly and in a timely manner with what's going on at an organizational level. If they don't have oversight of what's going on in data processing in a research area, that they're not able to fulfill their role. But what I will say is that adherence and data protection compliance is not just the data protection officer's job. They're there to inform and advise. They're there to assist in completing a data protection impact assessment, but it's not, in my view, their job to do that work. The best people to assess risk in relation to a processing operation are the people who are doing the processing. What the DPO will do is assist and advise as you go through that process of completing your impact assessment. It should not be left up to them to take on all that work and do it in isolation. I think I'm just approaching my 20-minute limit, so I'd just like to stress some key points that I think people will take away, and then hopefully we can go through some of this in the questions and answers. As I said, the key thing underpinning all of this is clearly understanding the roles of all parties involved in a research project at all points in the chain of processing, and to really think about data processing as an end-to-end thing, from when you enroll participants, when you start to collect data, all the way through to the publication of research, the deletion of data at the end of this. That's the all-encompassing sort of approach you need to have to understanding roles. Again, as I've kind of gone through, to understand that the health research regulations comprise part of the overall data protection obligations of your organization. They're not standalone. They fit into, at an organizational level, a data protection compliance package. And to ask the questions leading on from that is whether data protection in compliance in terms of health research is recognized as an organizational obligation where you work. And by that I mean, does your organization have knowledge, oversight, and understanding of the data processing that you conduct in your research? Because ultimately liability under the Data Protection Act falls upon the organization, and the exposure to organizational risk is very great if at an organizational level they do not have proper knowledge, oversight, and understanding. I think Peter's going to talk a lot about data governance, and that is absolutely key, that the organization properly governs all of the data undergoing processing. And finally, just to go back to my last slide there, get to know who your DPO is, involve them as early as you can in a project. Definitely don't come to them last minute with the DPIA asking them to sign something that they haven't had sight of. So I will finish up there, and happy to take any questions in the Q&A session. Thanks very much.
Thank you. Thank you very much, David. A huge amount of information there, and I know there are some questions coming in, David, and we're going to hold them until the question and answer session. I'm going to hand over now to Peter Lennon from the Department of Health. So thank you, Peter.
I'd like to thank Trinity College for organising this event. I spent many happy years here as an undergraduate student, so it's nice to be able to give something back. And I think, you know, it's a very important topic to discuss. Okay, the purpose of this presentation is to put the amendments made by the Minister for Health to the Health Research Regulations in context. And David has done that to some extent, but you'll see that I take a slightly different approach. Outline the reasons for the limits on and key themes of the amendments. Importantly, we had reasons for what we did. There were limits on what we could do, and there is a particular key theme, corporate governance, that I'm going to go through. And also, I'll set out what each of the amendments does, but mindful of the fact that next week there's a masterclass dealing with consent and capacity to consent. You'll forgive me if I don't go into too much detail on them now. I'm happy to answer any questions, but with 20 minutes, I don't want to dwell too much on them. Okay, David set out the legal framework for processing personal data in health research. And if you look at his slide, when you have the chance, and you look at my slide, you'll see there's a difference. David concentrated rightly on the data protection aspects. I've taken a slightly broader perspective. The European Convention on Human Rights, I think many people will be familiar with that, and decisions of the European Court, they have shaped privacy to a great extent throughout Europe. Ireland has ratified that convention. Now, on the national side, you'll note that I have not just the Data Protection Act and Health Research Regulations, I've got the Constitution and common law. And what's the reason for that? Well, the reason for that is because the processing of personal data, particularly the processing of personal health information, is governed not just by data protection law, but also by constitutional and common law principles. And they are particularly important in the context of privacy and consent. So I'm going to just say that if you look at the Irish situation, you have to look at privacy, not just in the context of data protection, but also in constitutional and common law principles that place a considerable emphasis on the duty of confidentiality that exists between a healthcare professional and his or her patient or client. And that's why consent is so important in the health research regulations. So back throughout, since the first data protection legislation in this country was in 1988. It was the Data Protection Act, very basic in its own way. It only extended to electronic data at a time when computerization was in its infancy. But if you look to the 2003 Act and the Data Protection Act 2018, you'll see that there are principles there. Transparently, which is a new principle, fairly and lawfully. They're core data protection principles, and they're found in Article 5 of the GDPR. So what does lawfully mean in a GDPR context? Does it mean that you just comply with the provisions of the Data Protection Act and that the processing is lawful? It doesn't. It means that the processing of the personal data must not only be compliant with data protection law, but also with other relevant law. And that brings me back to the point of the Constitution and the common law principles of duty of confidentiality between a healthcare professional and a patient or client. And it's the reason why the consent declaration process is set at substantial public interest. If you look at the health research regulations, it provides for the first time in Irish law a mechanism for a consent exemption. That has to be set at a substantial public interest level in order that it can justify being said to meet a common law and constitutional threshold. And this brings me to not a point as so much a question. Ethics committees, how much of the law do they need to know? I would argue that an ethics committee needs to have on it a person or persons with familiarity with the law, especially data protection and privacy law, because in an ethical context, privacy is a very important ethical principle. Next slide, please. Now, David mentioned, and I mentioned too, what the key theme of the amendments is actually governance. I'll take you back to May 2018, just before the General Data Protection Regulation came into effect in this country. The Data Protection Commission published a report on the hospital sector, and it showed that when it came to health research, there was a significant absence of corporate governance in the hospital side in terms of the use of personal data for which the hospital was responsible for health research purposes. The obligations in data protection law, as David pointed out, they're on data controllers and data processors. They're organizational entities. So in other words, you have to look at it like this. Trinity College is an organizational entity. St. James's Hospital is an organizational entity. So the obligations are on the entity. The employees and agents of data controllers do not exist or operate in a vacuum from the organization. Now, one of the issues that we came across when the regulations came out was, let's say a hospital consultant might say to us, but that information is my information. Well, if the consultant is a private consultant with a private practice, then indeed the consultant is the data controller. But if the consultant is an employee of the organization, then it is the organization that is the data controller, and it carries the principal responsibilities which its employees are expected to adhere to. As we all know, every health system in the world is unique, and Ireland is no example, is no different. And it's clear that universities and other academic institutions in Ireland need to be particularly aware of the governance issue when collaborating with a hospital or commercial body. I think there's an interesting framework of collaboration and joint appointments that exist in this country, where somebody might have a chair in a university and a consultant's position in a hospital, wearing two different hats, but from a data protection perspective, there's a need to distinguish those hats. And again, going back to the point I made, it's the institutions that are the important point in all of this. So the amendments, there are 5 substantive amendments. One, the first one is about pre-screening. The next one is low risk retrospective chart reviews. The next is deferred consent situations, informed consent obtained during the time of the EU Data Protection Directive, and explicit consent in the context of international best practice and health research. I know people will say, did we consult with anybody on these amendments? I'm happy to say that from the time the health research regulations were published in August 2018, we got lots and lots of correspondence, and we had lots of meetings, and we engaged as fully as possible with a range of people. I don't recall that anybody ever requested a meeting with us, and we didn't have a meeting. Some of the meetings that we attended, they were somewhat challenging, because what we found was that the health research sector, understandably, I have to say, found itself now having to deal with legislation for the first time. I think that it's all settled down now to the extent that it's part and parcel of the processing of personal data. It's part and parcel of building public confidence in the way patient information is used. And it's part and parcel of the General Data Protection Regulation itself, which everybody has to comply with. It's important to say some things that we couldn't do in the amendments. The health research regulations derive from the General Data Protection Regulation. So therefore, they can deal with personal data and the interplay between personal data and biomaterial, but they cannot address issues related to biomaterial per se. Some people think that's a weakness, that when the General Data Protection Regulation was being finalized, that they should have gone into more detail into the area of biomaterial, particularly genetic and genomic material. But I think that after 4 years of having worked on the regulation, they were somewhat tired and just wanted to sign off on it. We're also aware of the issues in relation to capacity to consent. because that was one of the first points that was raised with us. We pushed it as far as we could, but the substantive issues in relation to capacity to consent go beyond the scope of the health research regulations, which can only deal with data protection related issues. Another thing we'd hoped to do was to include an amendment to provide that the disclosure of pseudonymized personal data for research purposes to a researcher would be regarded as anonymized in the context of the disclosing data controller. If the recipient data controller formally undertook not to try to identify the individuals involved. But that was not acceptable at the time, but we continued to look at a way to see how that might be done. And the general point there is this: if you are an organization and you pseudonymize personal data and you hand it to a researcher, then certainly it's the case that in the hands of the researcher, the information is anonymized and outside the scope of the GDPR and the health research regulations. However, your disclosure of pseudonymized data is within the General Data Protection Regulation and therefore within the health research regulations. And the disclosure of pseudonymized personal data by a data controller is regarded as the same as the disclosure of identifiable personal data, notwithstanding that in the hands of the recipient, it's anonymized. Pre-screening. And pre-screening, this amendment was one of the first amendments that was brought to our attention as something that we should consider, and we undertook to consider it, and we introduced this amendment. It covers actions taken in terms of transparently processing personal data, which you must already hold to establish whether an individual is suitable or eligible for inclusion in a study. So 2 things there. It must be done in as transparent a way as possible, and you must already hold the information. It sets out who can process that personal data without explicit consent and rec approval, but both of them are needed for the substantive part of the study. So the exemption for explicit consent and rec approval only applies to the pre-screening stage. The 3 persons are health practitioner who is an employee of the data controller, or a healthcare student under the direction and control of a controller, other employees of controller who within the course of his or her duties have access to health records, for example, a medical records clerk, and probably the most important aspect of all, an authorized person. This is a person who is not an employee of the data controller. The example that's most frequently given is a research nurse who is employed perhaps by a university or academic institution, but finds herself or himself on the campus of the hospital and working entirely in the hospital. So who can be an authorized person? He or she must be an employee. Note, they needn't necessarily be a healthcare professional, simply must be an employee of one of the following organizations: an institution of higher education, a body or person that has as its principal activity the provision, management or development of a health practitioner. The ICGP could come to mind, or a registered charitable organization, because when we were talking to bodies like the Irish Cancer Society, etc., they said that they might actually be employing research nurses that they would make available. And so that final point in bold that I have there, formal corporate governance arrangements and higher level of transparency are required. Really what we're getting at is this, and it's the corporate governance point again. You can't have people walking around the hospital without the management of the hospital knowing who they are. You can't have people who are not employed by a hospital having access to personal data that the hospital has responsibility for if nobody knows that they're actually there. The organization, the hospital, the data controller must take full responsibility for that. Pre-screening actions, these are not actually defined in the health research regulations, but they are what we regard as the type of actions that constitute pre-screening activity. So they're relatively straightforward: reviewing the personal data subject, analyzing pre-screening data, sharing the findings in a non-identifiable way with others involved in the research team, approaching the individual to see whether he or she wants to participate in the study. And we say that this should be done only by a health practitioner. And then where the person has consented, sharing the identity of the individual with the research team on a confidential basis. So take a look at them. That's what we have been told by those involved in this area constitute pre-screening actions. Low risk retrospective chart reviews. When the health research regulations came out in August 2018, a lot of people raised the issue about retrospective chart reviews, particularly those carried out by students, etc., which were low risk. So what we tried to do was put together an amendment that would address that low risk issue. So the amendment has been drafted in a very particular way. It's framed and aimed only at low risk research studies. And you will note in that third endpoint, excuse me, that where the personal data has already been obtained by that controller for the purposes of provision of healthcare to an individual by the controller. This effectively means that the controller must be a health service provider. That's what we had in mind, that this amendment should apply to health service providers, to persons, health professionals working in those agencies, and students. Somebody asked the question, I think, about why aren't authorised persons included for retrospective chart reviews. I'm going to be honest and say the simple answer is that those that raised the point of authorised persons raised it only in the context of pre-screening. Nobody, to my knowledge or memory, raised the issue of an authorised person in the context of a low-risk retrospective chart review. Low risk. The health research regulations already require that a data controller proposing to process personal data for health research purposes must carry out an assessment of the data protection implications, risk of the study. So that's been there since 2018. It's a condition of this amendment that the risk assessment must be low. A DPO should be consulted and can help in determining what is low risk. However, we're not saying that the DPO should be the person doing these assessments. Basically, the DPO can be consulted and may give general advice in the institution about how risk can be assessed, but it would be unfair and unreasonable to expect DPOs to be involved in every retrospective chart review. We're saying that REC approval is required, and the REC considering the study must be satisfied with the risk assessment. I know some people will say, why must it be satisfied? Well, go back to the question that I posed earlier about RECs and the law and the fact that privacy is a key ethical principle. It seems reasonable that RECs should be satisfied that the risk assessment to the privacy of the individual is a low risk. Informed consent, EU Data Protection Directive. In relation to that, what we were told when we introduced the health research regulations was lots and lots of health researchers had got informed consent under the EU Data Protection Directive. And there was a concern about having to go out and get re-consent in those situations. We were assured that this was very widespread, that informed consent was standard practice. So I'm surprised to see that one of the questions that we've been posed today is a question that says, do we not realize that informed consent under the EU is a standard that can't be met? Because we've got the documentation, the correspondence from various parties that shows that informed consent was standard practice and that health researchers had adhered to informed consent during the currency of the EU Data Protection Directive. This is a good faith measure. What it's simply providing is that if you have informed consent that met the terms of the EU Data Protection Directive, we're not forcing anybody to go out and re-consent under any other terms. If it was good enough under the EU Data Protection Directive and you obtained it in good faith, we think in good faith you should be allowed to continue to use it. When does the amendment apply? It applies to a controller who is carrying out health research that commenced prior to 8 August 2018, where that controller has obtained the consent of the data subject to his or her personal data being processed for the purposes of specified health research, and the consent has not been withdrawn. They also must have a valid and lawful basis for the processing of the personal data in Article 6 of GDPR, and they must meet one of the conditions in Article 9.2, and they must comply with other applicable GDPR and health research regulations. So to recap on that, because I know I went through it quickly, it's a good faith amendment to reflect the fact that we were told that health researchers during the currency of the EU Data Protection Directive routinely, and it was a requirement of law to obtain informed consent. Explicit consent reframed, and in relation to explicit consent reframed, we just make this point that informed consent is something that has always been a core principle of, if you like, good ethical practice. Transparency is supposed to be another core principle that has been brought to the fore by data protection. Ethical oversight is another core principle of good conduct of health research. So we put those three principles together into the explicit consent definition. Now, can I just make the point that some people make a big issue about explicit consent and has all types of things that make it scary? The answer is no, and it's something I'll deal obviously in greater detail with next week, but all consent must be voluntary, it must be freely given. There mustn't be any element of inappropriate pressure or undue influence on the individual to participate. And in terms of explicit consent, it must be recorded. That's a key principle. Explicit consent has to be recorded. When the health research regulations came out in 2018, many people said that Ireland was way out of line with the rest of Europe in saying that there should be explicit consent. But the reality of it is that when you look at the guidance being prepared by the European Data Protection Board and by the EU Commission, and I've referenced it there, you will see that most European countries are taking the same view as us. They're taking the view that informed consent that is recorded is a very good safeguard for the conduct of health research. And they're basing that on the same principle that we did, that informed consent was always a basic principle, a core principle of good ethical practice. So rather than being on the margins of the European experience, Ireland has been very much right at the centre, and all good example, we would argue, has now been generally seen as the way forward for Europe as a whole. Deferred consent, again, this is an issue that I'm going to go into in much more detail. This is a very complex issue. That's all I will say. I would draw your attention to the first point. GDPR does not provide for anyone to give consent on behalf of an adult data subject where capacity to consent is in question. That is very significant. Even if you look at, say, the national vaccination program, etc., you can see that it's done on other legal basis rather than consent. So we looked at how much we could do in this area in terms of care and treatment and capacity to consent. And what we did was everything that we could. It's limited, and I'm the first to admit that. We need primary legislation to address these issues. That's the reality. And one of the areas where you could have primary legislation is in the Assisted Decision-Making Capacity Act 2015. As you know, at that moment, it covers health care, but it does not cover health research. You may also know that in the programme for government, the 2015 Act is due to be amended, and we're going to engage with the relevant government department to try and address the situation. But I can assure you that this capacity to consent issue in healthcare, and particularly in health research, is problematic and tricky. Maybe I should just say challenging. Everything can be resolved, but it needs primary legislation rather than secondary legislation. And final points. We will continue to listen and engage with those involved in health research and others with an interest in health research. In the consultation process we had on the amendments, we didn't just hear from people who carry out health research. We engaged with other people who perhaps took a different view on what the regulations should include. And that's what it should be. You have to engage with as many people as possible. As I said, we will engage with the Department of Children, Equality, Disability, Integration and Youth on the Assisted Decision-Making Capacity Act, because it used to be the Department of Justice that had responsibility for that legislation. Now it's that new department. I haven't said much about genomics, but clearly genomics is a huge area that's increasingly important and unfortunately also increasingly complex. If I was to recommend that you should read something, and I'll talk about this again next week in terms of consent in genomics area, the Information Commissioner's Office in the UK commissioned a study by PHG, which is a University of Cambridge group, looking at genomics and data. I'll send a reference on after this, but if you really want to read a comprehensive study of a complex area, it's well worth reading. Will it be addressed? It will have to be addressed. Is there public concern about genomics? Obviously, there's public concern about genomics. It brings the promise of major benefits to the health system, but also major challenges in terms of research and the safeguarding of personal data that may relate to more than just one individual. And finally, as the amendments, as with the health research regulations, the department, and importantly the Minister and the government, remain very much committed to the view that strengthening public confidence in health research is the way forward, and that it is everyone's responsibility. And that, thank you very much on my points. I'm happy to take any questions. Thank you.
Thank you very much, Peter. Again, we have a number of questions coming in and we will deal with them in hopefully in the question and answer session. I'm going to move on now with our next speaker, Professor Louise Gallagher, who's going to give a clinician's review of the amendments. Thank you very much, Louise.
First of all, thank you very much for organising this really important session, and thanks for inviting me to give the researcher's perspective. So I should say that I'm not an expert in data protection. I've been trying the same as everybody, I suppose, in the working in research to I suppose, to keep up with all the changes and to understand the impacts on research. So I'm going to give a little bit of a general response from the research community that, following the publication of the regulations, and then just maybe some reflections from my own area of research. I suppose I should say that I am one of those people who sits with two hats. So I sit between the health service and Trinity. Although as a psychiatrist, I don't maybe sit in a conventional kind of healthcare setting like a hospital, where many of our researchers might find themselves. I'm in a community setting, and that can present other challenges, but hopefully that some of the perspectives will have resonance for people. So, I mean, as Peter has alluded to, that once the health research regulations were published in 2018, concerns did emerge quite quickly from the research community. I suppose these were captured in a series of meetings, and many of the concerns included that requirement for explicit consent that Peter's just alluded to in his presentation, and also how there might be challenges with implementing the regulations, particularly where there might be differences, for example, in the interpretation of the legislation between institutions, or where there might be an impact on clinical trials, or where research could be slowed up due to protracted decision making, or the resource implications of the implementation of both GDPR and the health regs, and then the sort of the difficulties in navigating this new regulatory system. So a national survey was conducted by me et al. It was just published this year, and it showed that researchers still had, and this survey was conducted prior to the amendments, I should clarify, but researchers expressed a lot of concerns about, I suppose, issues to do with consultation about the health regs, although, as Peter said, the Department of Health have been engaging now quite proactively with researchers, but also difficulty with comprehending the health regulations, and maybe confusion in particular in relation to clinical trials, and how this might require, for example, amendments to clinical trial documentation to reach this threshold of explicit consent. People were worried about the impact that might have, for example, on non-interventional trials and on critical care, how it might impact on PhD training, and also maybe our capacity to be involved in large international collaborative research projects, and the way, I suppose, the bureaucratic burden might be impacting on researchers. And I think in qualitative feedback from that paper, there was also concerns expressed in relation to maybe retrospective application of the standard to establish studies, and the impact on informed consent and the resource implications. So I think, possibly there was a lot of confusion. The requirement for explicit consent did become a huge focus for the research community, and that need for explicit consent for data processing, and how that's getting layered on top of the requirement of informed consent for research. And actually, Peter said a couple of interesting things that maybe I found interesting and useful, and maybe I might come back with a couple of questions for him, because I do wonder if, as researchers, we might have sometimes overinterpreted explicit consent. And I have an example of that from my own research later that I'd like to show you. So obviously we know that the health regs set out that we require that personal data can't be, if it's identifiable, can't be included in health research unless the explicit consent compliant with GDPR exists, or a consent declaration has been granted. And this means that the data subject must give the express statement of consent, and that this should refer to the particular data set that is to be processed, the precise purpose of that processing, and then any risks or implications that arise for the data subject as a result of the data processing. And it should also provide any other relevant and specific information that might influence the decision of a data subject to give or not to give their consent. So in applying that to my research, for example, my experience has been that I've become very, very explicit with the type of consent that I'm seeking from a research participant, or in my case, because I'm often working with children, from their parents. And so the inclusion of explicit consent obviously is related to this additional requirement within GDPR for transparency. But I think that many researchers were feeling that that it was maybe unduly onerous and perhaps unworkable and out of keeping with the interpretation in other member states. Now, I know that Peter has indicated that that maybe this is changing in the European landscape. So in relation to explicit consent, so another paper from last year by Mary Kirwan highlighted the impact of the GDPR explicit consent on research, and that it raised issues for a number of specific areas that included the retrospective chart reviews, the pre-screening, conducting research perhaps in an emergency or urgent setting, the issue of capacity, biobanking, and then the need to reconsent to achieve that new legal standard of GDPR explicit consent. So consequently, I think that the amendments to the health research regulations were really welcome to give clarity. And as we've already heard, these address 5 substantive areas in relation to pre-processing, the low-risk retrospective chart reviews, deferred consent, and informed consent for studies that were conducted during the time of the European Data Protection Directive, and then explicit consent for processing personal data in health research context. So as my contribution here today is primarily really giving that kind of lived experience, if you like, as a researcher, rather than as any expert in data protection, I thought it would be maybe hopefully interesting for people to maybe just give some examples, some case examples from my own research, where I think the health regs have now provided clarity and have been helpful, and maybe where cases where I as a researcher perhaps still a little bit vague about things, or perhaps in some cases feel somewhat thwarted. So maybe to start with the pre-screening. So in the health regs, only healthcare staff, so the original published versions, only healthcare staff involved in the care and treatment of individuals could access the patient record of those individuals for pre-screening without the explicit consent of the individuals concerned. So this was a source of concern, as technically, in my experience, it could have precluded me from pre-screening potential study participants for clinical research or trials in my own health service where I work, because the original text specified that it should be done by someone involved in providing healthcare to the individual. And where that created, I suppose, doubt for me is that I would work in a situation where I'm part of a multidisciplinary team, and we have a large service, and there are many patients within the service, users within the service, but I'm not directly involved with the care of all of those service users. The MDT members might have different levels of engagement with children and families in the service at different times. So in order for me to know if a family meets the inclusion criteria for a study before approaching them to participate, I would need access, obviously, to their data. But if I wasn't the treating clinician, then technically I couldn't pre-screen the family. So the amendment was helpful by specifying who may conduct this pre-screening action. And I suppose in my case, that addition of an employee of the controller who ordinarily has access to personal data would mean that it would be then permissible for me to maybe pre-screen or to approach and then to approach a family. So in this example, we were doing a study of rare genetic variants in families with multiple individuals with autism and other neurodevelopmental difficulties. It was called the Autism Family Study. And the PI was a geneticist employed wholly in Trinity. And then I would be the co-PI as the child psychiatrist. So, and the inclusion criteria for this study would be that there would be 2 first-degree relatives with autism in a family and 1 relative with another neurodevelopmental disability. So now I think with the health regs, I can ask members of the multidisciplinary team if they're aware of families in the clinical service on their caseloads where there may be up to 3 affected individuals. They can highlight the families from their caseloads and I can check the files to ensure eligibility, or indeed I could delegate that task to a child psychiatrist in training. And then we could contact the family to seek their involvement in the study and for their agreement to be contacted by the research team. Now, a guidance, I think, with this particular amendment is that ideally the person who contacts the family should be the treating clinician. So, you know, if we wanted to be really sort of adhere to that guidance, we could always ask the MDT member to ask the family, is it okay for us to get in touch, for example. So still jumping through a number of hoops to do pre-screening for that kind of a study, but at least some welcome clarity. And it meant that we could continue to look for these families within the clinical service. The same study ran into a little bit more difficulty, however, due to lack of consensus on the interpretation, what I believe is a lack of a difference in the interpretation of the health research regulations between 2 HEIs. So we had recruited around 50% of the sample, and those biosamples were due to be sent for whole genome sequencing. And it was designed, the study was obviously designed and recruited at a time when it was assumed that the research will be completed wholly in Trinity. But of course, as it would be routine in my research, because I'm frequently sharing data with research collaborators, we would always consent our research participants to data sharing with collaborators. That would be quite common in the field, and particularly with genomic studies. Now, happily, in some respects, the co-PI in the study was appointed to an academic position in another HEI. But after our initial sort of celebrations on the PI's behalf, we encountered difficulties then following the move. So following the move of this PI, it was also the PI and a PhD student moved to the new HEI. And a key issue for the new HEI is that they wanted to have ethical approval within the new HEI for this study. So they weren't happy to accept the ethical approval that was in place and sort of just work under maybe the basis of a data sharing agreement with the PI in the new HEI operating in effect as a processor. That might have been the simplest outcome. But one of the key issues is that they didn't want to accept the TCD St. James's CHI TALA REC approval for the project. And they wanted additional REC approval, and more specifically, the consents were not deemed to be sufficient because they didn't specifically name the new HEI as a collaborative partner or a data processor. So they said to us that we should seek reconsent for the new HEI involvement in the project that is explicit, gives full details of the project, of the new HEI role and the right to withdraw, etc., and that we should submit those information sheets and forms to the ethics committee. Now, of course, we didn't have a crystal ball when we were designing the study, so we aimed to cover our bases by stating that there would be data sharing, but there was a narrow interpretation, in my view, of explicit consent in relation to data sharing. And they also, I thought, you know, it was kind of interesting that the REC was suggesting that we in another HEI, they were sort of dictating what we would use our resources for, in the sense that we should update our REC and our consent forms for already recruited subjects. And I think that this sort of highlights some of the issues raised previously by the research community about different interpretations and maybe overly restricted consent definitions or interpretations of those consent definitions. And, you know, this clearly has an impact on the PhD student and also places additional burden on study participants who may not understand and then are being requested to go through an onerous consent process all over again. So moving on to the next example, and I'm really glad that this is going to be discussed in more detail next week. I think one of the issues that probably has developed since the health regs were published is the way explicit consent has been interpreted and obtained through research studies. And there is a question as whether or not it's truly informed consent. So this last example then is from another research project. So I wanted to sort of give you an example of how complicated consent has become. And I think that this is particularly in relation to the data processing, because I suppose we heard and understood, or at least I did as a researcher, that unbundled consent, is required for transparency as part of GDPR. So it's necessary to clarify what data processing will occur with someone's data. And explicit consent means that the data subject has to give the express statement of consent. So, and as I've already mentioned, that's defined in terms of the data set to be processed and so on. But I suppose one does wonder at what point does the information provided and the consent become so long and technical that it's no longer understandable for a study participant. So to illustrate what impact this has had in the last 2 years, I thought I'd show you some pills and consents that we developed and had to amend for a European study. So this is a pan-European study called AIMS2 trials. It's related to the development of biomarkers and new drug therapies for autism. And it's a multi-site study, and it's a real data protection quagmire because we collect genomic data, behavioral data, neuroimaging data, and audio and video recordings. So just a very quick sketch of the data flow in the project. So it involves data flowing from the study participant to the clinical and neuroscience researchers in Trinity, and this is a combination of all the medical and clinical data and the neuroimaging type data, plus the blood samples that we obtain. We then can share that data with our researchers who are primarily focused on analyzing genomic data. The data also flow then to the Institut Pasteur, where there's a centralized repository, the biological samples go to a centralized genomic facility for whole genome sequencing and then get sent back to the lab. So this centralized repository can share the data with members of the consortium and ultimately the scientific community more widely, both within and outside the European Union. Added to that, we have to consider the potential that we could identify incidental findings, and we need to communicate these, if possible, with the participant's GP. So this could be related to the genomic data, or it could be related to the neuroimaging data. And also, this is a study that involves families and people with reduced capacity. So we need to consent parents, guardians, adults with capacity, and then we have to have assent forms for those who don't. So in the pill, you'll see, the current pill runs to, I think, 8 pages, and it provides very detailed information regarding the study procedures. So, and the data protection arrangements. So obviously we have to give the background about the study. We have to, the right to refuse to participate, what's involved in taking part, and because it's a complex study, there are multiple visits that they need to be told about, the fact that they're not going to benefit directly, what the risks are in relation to all the research that the participant is involved in, and then the issues around incidental findings and what we need to do in relation to that. What information will be used, so how will the data be used and processed, what happens to the data, and who will access the data, and will it be kept confidential, and how, issues around future use of the data, and the lawful basis of data processing. Then the issue if the child turns 18, we have to reconsent the child, and so on and so forth. So it's, as you can see, it's a very lengthy pill. And then I just wanted to go back then to my PowerPoint, because I also wanted to show you then, and this is where I wonder sometimes have we overinterpreted how much we need to consent people then in terms of the unbundled consent. So this is some example of the first couple of pages of the unbundled consent form for the AIMS2 trial. So it runs to 4 pages in total, and it contains sections on the understanding of the details in the pill. That's here, the consent to the future use of personal data, the consent to audio and videotaping, the procedures for incidental findings, how this is an parental consent form, so how their data will be used, how their child's data will be used, do they agree to future contact for future research. So I have to say that although I was intimately involved and have to take responsibility for the complexity of this consent form, when I went back to review it for this presentation, I was actually quite bowled over by the amount of information that we're expecting people to take in. And this is only at the start of a very long research process. So I really find it hard to imagine that a parent, particularly with a disabled child, might sit down to read all this information and the list of consents that they have to tick. I was reflecting on my own kids who are late teens, early 20s, and thinking, would they actually sit down and digest any of this information? And they don't have any cognitive difficulties. And yet I feel that we're asking families and individuals, and some of them have cognitive difficulties, which doesn't mean that they've got impaired capacity, but they might have, more limited understanding of the information that we're presenting, even though we do try to adhere to the readability of the consent forms. So, I mean, I do think that this is a challenge for us. I think that we probably need to have more kind of discussion and understanding of it, because I wonder if, some of this is my own fault as a researcher, that I've been overly sort of cautious about how I collect consent for a complex study such as that one. So then, just to conclude, I just thought I'd share some other reflections on the broader impacts on the process of the health regs and the process of research. I mean, I do think it has created a heavy administrative load. We've had to do multiple ethical amendments in the last 2 years, maybe an average of 1 or 2 per study. And of course, we have to do, for the studies that are ongoing, and we have to do the DPIAs and the data management plans. The newer studies have been easier to manage during COVID, but actually, so we do have the documentation and that can be adapted, but most of our research during COVID has been survey-based research, so it's really not very complex. And I thought that the final quote was good, just to put a quantity on the impact, and this came from the Me et al. Paper. It was from Mark Little. It was just some of the qualitative feedback. So in his study, he reflected that over a year, they had diverted most of their resources to aligning with the research regulations, and that the research had to take a back seat, and they couldn't have rebooted a health regs compliant registry and biobank without close and ongoing support from the local CRF regulatory affairs team. And they'd spent €17,000 and still counting, which they had to divert away from research. And I think that this is really important for us to think about, and just to keep in this discussion that we're having, because, not only have we got the health regs to deal with and that legislation to deal with, we're also in parallel, more generally in research, there's more emphasis on the development of open research, and, we have the framework for development of open research, or NORF, in Ireland. And of course, we see these things as positive, but it will create more administrative and process burdens on researchers without, who are already kind of quite significantly burdened by administrative aspects of their research within a relatively low resource environment in comparison, maybe with researchers who are operating in, the North America or other European, Western European countries. So I think it does affect our competitiveness and our ability to continue to engage in highly impactful research. So I really, really welcome the opportunity to have this discussion, and I'm going to leave it there for now.
Thank you very much, Louise. And I think getting the practical issues and what this means in day-to-day work is just so important. I want to thank all of the speakers. We haven't as much time as I thought we would have for questions, but we will get back to people in relation to questions. But Louise, just going back to your point in terms of the whole issue of explicit consent, and when I look at the detail in terms of the forums that you have, completed there, and the information sheets that you have completed, much of my work, and I might ask Peter, perhaps, or Emily to respond to this, really involves people with a learning disability, an intellectual disability. And, you know, the development, and many of them would have great difficulty in understanding that volume of information. We utilize the NALA guidelines, and we have a lot of easy read, etc. But we have a lot of people who are not able to consent to give explicit consent. And our normal practice would be that we would do our best to get the individual to consent themselves. All of these are adults, they're all over 18. And for people where we can't get consent, we would generally have an agreement from a family member, perhaps, to allow their family member to participate in the study. But when can we expect legislation to permit proxy consent for this type of research? Maybe David, I might give that to you first, and then maybe to Emily or Peter, whoever wants to take it.
Yeah, thanks, Mary. I might just comment briefly on that. I think, you know, as Peter mentioned, our legislative frameworks don't currently allow for the giving of consent for the processing of personal data by an adult on behalf of another adult. We know that there's, I suppose, a legislative gap. Under the Data Protection Act 1988, there was a facility whereby a hierarchy of family members could give consent for the processing of personal data. This was not repeated in the Data Protection Act of 2018 and does not appear in the GDPR. Our understanding when the Data Protection Act brought through in 2018 was that the Department of Justice intended that the Assisted Decision-Making Capacity Act would cover for this situation. But we're in the situation now where there is you know, a gap in that space. It's not the role of the DPC to you know, to put forward public policy on this. Obviously, that's the role of the department. But I think you're correct in saying that there is a difficulty in that space at the moment. On consent in general, I mean, I think it's possible in those situations where you're dealing with people who have difficulties in taking on information but are not deemed to lack capacity. The European Data Protection Board has published guidance on transparency under GDPR that talks about the adoption of a layered approach, you know, trying to use sort of simpler language to explain concepts, taking the time with individuals. So it's taking into account the situation of the individual. So while it's obviously not fair to present a very, you know, lengthy and wordy list to individuals who mightn't understand it, there is, of course, you know, scope for you to develop other procedures around that, having an individual perhaps on hand who's able to explain it in clearer terms and ask clear questions. As to whether so I think all of that, you know, builds in and can be considered as reaching your consent requirements, rather than presenting a very long text and saying, you know, if the person doesn't read and sign this, then we can't accept it. I think the GDPR, and I would put people towards looking at those guidelines, and we can definitely share those in terms of offering ideas as to how to reach how to get to that consent threshold.
Yeah, we would utilize those already, and we would go to the HRCDC as well for approval. Emily, I'm not sure if you want to add anything to that.
Yeah, can you hear me okay?
Yeah.
I think, yeah, it's really important. It's a really good point. And I think from the observations we've seen from applications coming in this particular area of research, the easy read consent forms are actually, our committee have often commented how useful they are to them actually in getting the information across in an easy to understand manner to the individual reading it. And I think generally speaking, whether it's intellectual disabilities or it's in an emergency care scenario, getting assent from an appropriate individual who's acting as a proxy, who understands the will and preferences of that individual, is equally important. And it's a really important safeguard as well, to get those perspectives, to make sure that, you know, and there's ethical considerations to that as well. But I do think that the information that is being provided to the individual, whether it's the participant or the proxy individual, it's important that that is understandable and it's centered for them as well, because they're the ones who are taking on that information and need to understand what kind of decisions they're making.
Yeah, okay, thank you for that. Another question has come in, and I know you spoke a little bit about it in the earlier presentations, but I'm just going to ask it anyway. Is verbal consent acceptable, or does it have to be written? So if you're getting consent from somebody over the phone, can you as a researcher record that as a valid consent if the person verbally over the phone says yes, I consent, and is that suffice? Perhaps Peter, you might want to respond to that.
Well, I'll respond in the first instance, but I think that David would be the authority. We did discuss this question in advance, and the answer is in principle, yes. There is the key aspect to it is this. The virtue of actually having something recorded is that it means that this documentation to prove that the engagement took place and that the individual was fully advised. But in principle, there's no difficulty with something being done over the phone. The difficulty can emerge at a later stage if somebody says, well, actually, that's not my recollection of events. So from an enforcement perspective, I would ask David to type a comment on how the DPC might regard such an issue.
Thank you, Peter. David?
Thanks, Peter. I'll just speak very briefly on that. So when you're looking at consent under the GDPR, you need to look at, first of all, the definition under Article 4, which sets out the requirements for valid consent, that it is fully informed, specific, unambiguous, etc. But then also Article 7 sets out what validates the processing of personal data on that basis of that consent. And really, all it requires is that the controller can demonstrate that valid consent is obtained. So while a written expression will do this, a verbal consent will suffice where the controller is able to, I suppose, stand over the process. So, a contemporaneous record made by the person obtaining the consent in a verifiable manner that the conversation took place, that the person did provide their consent. There's no requirement in the law for a written consent. Verbal consent will do, as long as you're satisfied that you can stand over your consent gathering procedure and answer that question.
So that's helpful. So you could make a contemporaneous note of that to say that this conversation happened at such a time and this was done. Another way you could do it maybe would be to send a copy of that note to the individual as well, if you wanted to do that, and we have sometimes done that as well.
Exactly, there's options there, yeah.
There's options there as well. Okay, a further question. The requirement that the area of research be specified in advance of data collection can be difficult, particularly in the area of genomics, and this has already come up. Is there any guidance on how to specify the areas of research in order to comply with the health research regulations, or is genomics too broad an area to specify? So who would like to respond to that?
Well, I'll take first bite at it, Mary. I'll say that it's a very fair question to ask. Like, one of the things is that, leaving genomics aside for the moment, that the health research regulations do not allow blanket consent. That's the first thing, and blanket consent hasn't been allowed for a number of years anyway. So it allows broad consent. So if you wanted to get broad consent, then you formulate it in a way that it constitutes broad consent. For instance, one could say that cancer studies. So one might start off by saying, I'm doing research on, say, breast cancer. But then perhaps the individual should have thought about the fact that maybe that research would feed into wider areas of cancer. So I think that the onus is on the individual when he or she is commencing the research project to think about not only the research that they're doing, but the research that might emanate as a result of that research in the same area. In terms of genomics, I have to admit, it is complicated. I'll go into a bit more detail next week, but I'm not going to give any definitive answers. In fact, next week, what I'll actually be doing is pointing out the difficulties in the area rather than the solutions, because it does give rise to a lot of challenges, and that's all I'd say. There are so many issues with the genomics thing, and like, we can talk about research too, and when we talk about, say, studies that have been done, it shows that public confidence in health research is much higher when only academic institutions are involved. Public confidence in health research declines very quickly when commercial companies are involved. And so if you have commercial companies involved, not just in the genomics area, but in any area, it raises issue about the consent threshold and the consent protocols that have to be in place. I'll go through some of them next week.
Okay, Louise, do you want to add anything to that from a clinician's perspective?
Well, I suppose the issue probably just more from doing research in genomics and then the clinical implications of that, because I think genomics is a really special case where so much of what we do is in the research setting is increasingly coming into kind of clinical, becoming clinically relevant. So when I read that question, I thought really, I mean, I think there's the issue that Peter's alluded to, which is genomics is very, very broad, and there are many different things you can do in a genomic study that go from a level of anonymity, relative anonymity, to potentially an individual being identifiable from their genomic sequence. But for me, the ethical consideration here is that what if you consent somebody to a study and you hold their sample, and then down the road you do something that might reveal that they have, some kind of finding that needs to be actioned, and then you go back to tell the person, or you feel ethically obliged to go back and tell the person, but you haven't told them that this is that this potentially could arise in the future. So I think that there's an ethical issue there. I think you probably need to give people information. I suppose I could just share that we do that in our studies, and people always want to know. So that's just my kind of own experience.
Yeah. Okay.
Can I just come in and add to that, Louise, that one of the issues too is that your research might actually identify that the individual concerned has a particular issue, but maybe it extends beyond that individual to other members of the family. And that's where it becomes really problematic, because they were never even aware that the research was taking place. And I think that's one of the big challenges, that genomic data extends wider than the individual concern, which raises a fundamental data protection issue about the definition of personal data. And I think that's where it all starts, and ultimately we'll come back to.
Okay, thank you. I am concerned about time. Under the health research regulations, is a register of people who consent to be contacted for participation in research projects permissible? Is this allowed? And their consent would include consent to pre-screening for such projects. So Evelyn, perhaps you might want to answer that.
Well, I suppose we've already covered part of the question in that the pre-screening aspect wouldn't require the explicit consent. I think maybe the question is relating to what legal basis would you rely on for the retention of the register of contacts. So I'd probably suggest in this situation that you do rely on consent, because it's a register of contact names, and they should be able to withdraw that consent as they see fit. And I suppose the other thing to remember is just to make sure that you're transparent with them in advance of gaining that consent. So some kind of privacy notice would probably be advisable as to, the reasons why you're going to keep this list, and, the retention periods and all those things that we advise that you should put in a privacy notice.
Okay, thank you. Thank you for that. Okay. Will hospitals or institutions have the opportunity to be consulted on the authorization agreement for pre-screening at institutional level and at the level of the appointment of individual? Maybe Peter?
Okay, thanks, Mary. What I would say is that the HSE have done a tremendous amount of work in this area, and they're developing a document that will be particularly relevant to their own HSE hospitals and institutions. But as I understand from the head of research and development in the HSE, they're happy to share it with others. And I think others might find it a very useful template in that regard. That should be available in the next few weeks.
Okay, thank you for that. In relation to retrospective chart reviews, which DPO is responsible for the analysis of risk? And this is a couple of points to this question. Is it the site DPO or the controller of the research data? And is it not a crossover into the DPO space to request ethics committees to review data protection risk as part of retrospective chart review process? Peter, do you want to?
Thanks, Mary. What I'd say is that the amendment in relation to retrospective chart reviews was tightly drawn, and it was drawn on the basis of consultation and engagement with universities and with hospitals, particularly those that had a lot of medical students who would be doing retrospective chart reviews of a low risk. The amendment, and it says it in my slide, it's effectively aimed at a health service provider because the data controller concerned must be a data controller who A, already holds the data, and B, already holds that data as a result of providing care and treatment to the individual. So therefore, the analysis of risk must be carried out by that data controller, since it's their data that is at hand. And in relation to the second aspect of the question, is there a crossover? In anticipation of that question, I did raise the issue about the role of a research ethics committee. Privacy obviously is a key ethical principle. And when it comes to, in a sense, even if you didn't have to have research regulations and you didn't have GDPR, a REC would have to have regard to privacy and the risk to privacy. So in a sense, it seemed to us, and again, on the basis of engagement with a number of individuals in the area, that it was reasonable that the REC should continue to have a role in assessing risk and bring their assessment of risk to bear on the assessment that the person carrying out the study had actually done, in the same way that it might challenge an individual on other aspects of the application that they have made. So I think that the role of a REC is to look at the application, consider the evidence provided, and to adopt a question and approach to it, and we simply continued that.
Yeah, okay, and there has been another comment that has come in, that particularly in the area of mental health, that people sometimes can find that ethics committees can be paternalistic when it comes to research with service users and render them voiceless. And so that can be, which often results in, I suppose, that it's only the healthy well and who are able to consent that are maybe included in studies, and those who are most vulnerable end up not being included because it becomes quite difficult. So that's just a comment that has come in. We're now 5 minutes over time, and I'm going to close the questions and answer sessions there. We will respond to the questions that has been submitted and get back to the various people. We'll put it up on the site. I just want to thank David Murphy, Peter Lennon, Louise Gallagher, Emily Vedkar and Evelyn Fox for their contribution today. I think it was a great session. We will have another session next week. And I want to thank you all for joining us. I also want to thank Michael Foley and Gavin Dan from my own team, who did all of the administrative work behind the setting up and my own group at the Trinity Centre for Aging and Intellectual Disability. So thank you all very much.